Let me ask that same question to both George and John here, our two guests who have been kind enough to spend the afternoon session with us here. Do you think, and John, I'll start with you, do you think, given the nature of the defense here, that this was a terrible accident, does Scott Speer pretty much have to get on the stand to tell his story, or can you defend this without putting him on the stand?
I would not put him on the stand in this case, and I'll tell you why. This case is a sufficiency of evidence case, and you have a shot at the trial, and you have a shot at the appellate courts if you don't win a trial. If he gets on the witness stand and testifies and he gets convicted, the appellate court's going to say they heard his testimony, they believed what he said, or they didn't believe what he said, and so there's not going to be any sufficiency of evidence argument. This is a paper-thin case, and so in this instance I wouldn't put him on, although you can always consider it. You have to look at the totality of the case. I would say right now, if you had to ask me, I wouldn't put him on.
George, what do you think?
I agree with John 100%. It is a paper-thin case, and why on earth would you give the prosecution or help them establish motive or intent, which they have not proven to any degree whatsoever, that you would be helping them do that? He may walk into a question that makes one or two jurors or all of them believe, you know what, maybe this guy did do it on purpose, or he did intend to kill him. They have not proven anything up until this point. I see no reason whatsoever to call him as a witness.
Now, I don't know that anybody would disagree with either of you on that assessment of what's going on inside of this courtroom.